going to get started because it's getting a little late. Welcome, everyone. I'm Dan Schrag, and I'm really delighted to have Dan Bodansky here today from Arizona State University. Dan is a law professor, an expert in international environmental law. And, you know, in the whole discussion that has been going on over the last many years about solar geoengineering, I think emerging is the big question of governance, of how does the world manage this technology that many people think is an inevitable response to our lack of progress in decarbonization. Putting aside the question of whether that's appropriate or not, is the question of how does the world manage this system, and Dan has a very special perspective as thinking about international law, about how do you actually go about doing this. So he's going to ask the question about what international law says, what it should say, what it might say. And I think our hope is that this will be a little provocative and maybe have a vibrant discussion afterwards. So Dan, welcome to Harvard. It's great to have you here.
Well, thanks very much. Is the microphone working? Can you hear me back there? Okay. Well, thanks, Dan, for that introduction. It's a pleasure to be here. So my talk today is entitled International Law on Climate Change, Is There a There There? And since I know you're all at the edge of your seat wondering what the answer to this is, I'll give a spoiler. So there is a there. It's a pretty small there, but there's a bit of a there. So it's not the case that some people sometimes claim that international law has nothing to say about climate interventions. It does have something to say. It doesn't have a lot to say, but it does have something to say. So just since most of you are probably very familiar with climate interventions, but I just have two very quick slides in case someone is not. So climate interventions, or climate engineering, or geoengineering, the different terms are used, encompasses a whole range of different techniques, including things like putting particles, aerosols into the stratosphere, putting iron into the oceans to fertilize the oceans. And in general, people distinguish between two different types of climate interventions: solar radiation management to reflect sunlight away from the Earth to cool it off, and the other is carbon dioxide removal, or more broadly, greenhouse gas removal, which involves trying to remove greenhouse gases from the atmosphere. Now, often people distinguish very sharply between those two, and I would agree with that. My talk today doesn't really sort of encompasses both to some degree. It's focused mostly on solar radiation management, but I think what I say is going to be also applicable to carbon dioxide removal. So that distinction in the context of this talk is less important, I think. So climate interventions, as you probably know, quite controversial. A wide range of views on climate interventions. At one extreme, or one end of the spectrum, I don't want to say extreme, that's pejorative. At one end of the spectrum, many view climate interventions to pose unacceptable risks. They want to basically never do climate interventions under any circumstance because we're messing with nature in ways that are unpredictable and could lead to catastrophic harms. At the other end of the spectrum, a much smaller number of people think we should be undertaking climate interventions essentially now, that we should at least start ramping up climate interventions to alleviate climate damages, prevent tipping points from taking place. And then there's the middle ground, that climate interventions might be an acceptable policy. We're not ruling it out altogether, but only if the research shows that it's safe and effective. And then I have here in brackets, and also if there's effective international governance. I think what would constitute effective international governance is extremely unclear. Is it achievable ever? I put it in brackets because, at least for me, I wouldn't necessarily put that as a precondition to use geoengineering, but it would be, of course, desirable. And I'm just curious to get a sense of my audience. So how many people would be in the left-hand side of the spectrum? Climate interventions pose unacceptable risks, and we shouldn't do it at all. Okay, a few. And how many think we should be going ahead with it now that we know enough and climate change is a sufficient risk that we should start slowly ramping it up? Anyone? And then how many are in the middle? Okay, so vast majority. Well, that's good to know because my own view is in the middle, so we're all in agreement. I can end my talk now. I think solar radiation management research is urgently needed to better understand the risks and benefits of climate interventions, how it might be done most safely and effectively. This is without prejudice to whether we actually use it, because we need to know more about its effectiveness and safety before we would consider using it. And my view then, allied with that, and so these are the premises of my talk, is that deployment's premature. Before it's undertaken, we would need to know more about the science and technical aspects of engineering, and we should at least, at a minimum, whether or not effective governance is really ever achievable, we should at least try to be having many more informed discussions about when climate interventions might be undertaken in a responsible and appropriate manner. So we need much more discussion of this, I think at all levels, nationally and also internationally. Okay, so if we're thinking about what governance of climate interventions might be, I think the function of governance is really largely a matter of what our concern is, what we would like governance to do. So, of course, if you think that climate interventions are immoral or unacceptable, then the type of governance one would want would be a moratorium or ban. If you think that it might be carried out in risky or irresponsible ways, you want to be doing standard setting to regulate the use of climate interventions. My own view is, because my focus is on the need for more research so that we better understand the risks and benefits of climate change. Really, it's the third here concern, insufficient research. So we need to address barriers to research, barriers relating to lack of funding, to questions about the legitimacy of it. We need to be able to coordinate research better. So then the functions of governments are to develop a research agenda, promote cooperation and information sharing, transparency, and so forth. So what we think governance should be doing is a function of what our concern that we're trying to address is. Okay, so just an outline of what I'm going to be talking about. First, I want to talk a little bit about what existing international law says, if anything, about climate interventions. And then secondly, look at the question of what more could and should international law say about climate interventions going forward, looking at three different options, essentially. One is a moratorium on deployment, which has gotten a lot of attention recently. Secondly, some kind of international decision-making mechanism, procedure on deploying solar climate interventions. And the third would be other types of governance, which is what I'm going to be actually focusing on. So, and the key messages, my key messages for today are, first of all, existing international law does provide a general framework to evaluate solar climate interventions, but it doesn't prohibit or limit it. It provides essentially broad evaluative standards that can focus discussion about the merits or demerits of climate intervention. It doesn't address the broader political or ethical concerns, I don't think. It's self-applied by states. UN Security Council is really the only potential existing institution that can make decisions. So there is some existing international framework, which I'll go into more in a minute. But then there's also, I think, a limited additional role that it could play. So looking forward, I think realistically, there's limits to what international law could do. It's unlikely to be able to effectively prohibit climate interventions or even to regulate its use, but it could promote cooperation and transparency. So that's just a broad overview of what I'm going to be talking about and sort of the key messages that I hope to maybe take away from this. So looking at existing international law, there's quite a lot out there actually that's relevant to some degree or another to climate intervention. So there's a whole series of different treaties, the Framework Convention, Paris Agreement, Montreal Protocol, which deals with protection of the stratospheric ozone layer. CLRTAP is the Convention on Long-Range Transboundary Air Pollution Convention, which regulates at a regional level emissions of sulfur dioxide, UN Convention on the Law of the Sea, the Environmental Modification, the whole panoply of treaties. None of them is really directly on point. So all of them are to some degree relevant, but really none of them directly addresses, in any sense, climate interventions. I think the areas of international law that are more relevant currently to climate interventions are customary principles. There's the duty to prevent significant transboundary pollution. There's the precautionary principle, which says Basically, you don't need to wait for full scientific certainty to take action to address serious environmental risks, duty to assess environmental impacts, and then duties to notify and consult with potentially affected states. These customary norms have gotten a big boost recently from the advisory opinion from the International Court of Justice on climate change, which came out in July, which basically some of these may be questions about their customary law status, but the International Court of Justice took a very robust view as to these customary obligations to basically use due diligence to prevent significant transboundary pollution, which then entails also duties to assess, to notify, to consult. So these are the existing rules and principles. So it's not the case that there's nothing on climate interventions. If you were doing a climate intervention research experiment, for example, that might have significant transboundary effects, certainly if you were deploying climate interventions where there would clearly be significant transboundary effects, states would have a duty to use due diligence to try to limit potentially negative effects, to do assessments in advance, to notify and consult with other states. In this case, it would presumably be, if it's talking about deployment, consulting with the entire world, because the entire world would be affected. And these are existing international obligations that apply to any activities a state's doing, including climate intervention activities like putting aerosols into the stratosphere. There are also quite a few different existing international institutions that are relevant to climate interventions. There are scientific expert organizations like the International Council for the Scientific Unions, the World Meteorological Organization, the World Climate Research Program. There are the different treaty bodies established under different international multilateral environmental agreements like the UN Framework Convention, the London Convention, which deals with dumping waste in the ocean, has taken quite an active role in putting forward norms about putting things into the ocean to try to sequester carbon. So that's another example. The Convention on Biological Diversity Conference of the Parties has adopted a number of resolutions on climate interventions. So there are all those different institutions. Then there's the Security Council, which has authority and mandate to address threats to international peace and security. So to the extent climate interventions were deployed in a massive way that could lead to security issues, to international tensions, then the Security Council could get involved. And then you have the judicial bodies, the International Court of Justice, the International Tribunal for Law of the Sea. So lots of different treaties, a number of different, I think, relevant customary norms, and then lots of institutions. The institutions, as I say, like the treaty norms, it's a patchwork. There's a lack of good subject matter fit for most of these. They have very little regulatory competence, with the exception of the UN Security Council. So the role, really, I think, of these organizations is largely, currently at least, to provide a forum for consultation. So they provide a forum for policymakers, scientists, others to consult. They provide opportunities for collective learning. They can develop norms. So there's Convention on Biological Diversity, the London Convention, which deals with dumping of waste in the ocean. They've developed norms that apply to certain types of climate interventions. They provide technical expertise and assessment. The Montreal Protocol Scientific Assessment Panel has now put out some reports on the effects of solar aerosol injection on the stratospheric ozone layer, so they can do assessments. They can help coordinate activities. So the World Climate Research Program has now established a lighthouse project to try to coordinate research on climate interventions internationally, so that there's a division of labor and different research issues are addressed by different groups. And then potentially they could play a regulatory or decision-making role, but there it's really, I think the only one with much decision-making authority, at least potentially, would be the Security Council. And of course, if any of the 5 permanent members did climate interventions, US, China, France, UK, and Russia, they have a veto, so the UN Security Council would be effectively disabled from taking any action. But if another country did, and it was a threat to internet, it was massive, sort of like a ministry for the future kind of scenario, then potentially the UN Security Council would be the existing international institution that could try to address those threats. Okay, so some main takeaways about existing international law. So this is just to sort of sum up what I've been saying. I think it provides a general framework to organize and structure discussion. So it's not we're starting from square one in discussing climate interventions. There are international norms that are relevant here about using due diligence to try to limit transboundary harms, to assess, to notify, to consult. They don't give specific answers to questions like, can we put a certain amount of sulfur aerosols into the stratosphere in a research experiment? No, there's no, it doesn't provide that level of detail. It provides basically a structure to discuss that question. It doesn't prohibit really anything at the moment. It really only addresses the transboundary physical effects of climate interventions. It doesn't deal with the kind of societal issues that many people are concerned about. For example, that climate intervention research will be an excuse not to do more emission reductions. And then finally, and maybe one of the most important points, all of this is just self-applied by states. There's no third party that is applying these rules. So that's why I say these rules structure discussion, but it's really a matter of how seriously states take it, how seriously they apply it to their own activities, how much they're willing to criticize others based on these norms. There's self-application by states. Okay. And then just a final point I wanted to mention, because I think this comes up a lot. I think there are often claims that solar geoengineering deployment would require international approval or governance, that we can't do it. And all of this, of course, depends on what we mean by required. What kind of requirement is it? So you might think it's a moral requirement, that it's immoral for one country to be making decisions for the entire globe. And so I'm sympathetic to that view. I don't know if it's decisive, but it's certainly an issue morally as to whether it's required. Politically required, that you couldn't do it as a matter of politics, I'm not sure that's really true, because I think certain states at least would be able to politically go ahead with it. And I think when we see what the current administration of the U.S. does without any international approval, all bets are off as a political matter, how much states would be unwilling to do things without some international approval. Depends on what state, of course, is involved. But then I think the only one I'm really qualified to speak on is legal issue. Is it legally required? And I think there the answer is no. There's no current international law that would prohibit a country from going ahead with solar radiation management with climate interventions currently, because international law really provides just some general principles. As I say, that structure debate. They don't provide specific rules that would actually prohibit this, nor, I think, as I will say later on, could it, because I think even if it tried to, whether those rules, those prohibitions would actually be effective, I think is extremely dubious. Okay, so just thinking ahead now, what roles could and should international governance play going forward? It's playing a limited role now, but not a completely negligible role, but a modest role currently. What could it play going forward? And I think a lot of times when people talk about governance, they're thinking about decision making, they're thinking about authorization. Governance means that there's some international body that would decide whether or not to allow climate intervention to take place. That certainly is one aspect of governance, decision making, but it's not the only thing I think that governance can involve. So governance, I think, involves a whole series of different kinds of functions, and I think in thinking about what role international governance might play, it's important to recognize that there are a lot of different kinds of governance functions it could play. So first of all, it could simply provide a forum for consultations and discussion. So the UN General Assembly doesn't have a lot of decision-making authority, but it provides a forum for countries to talk about different issues. And so I think that, broadly speaking, is a governance function that's serving. Assessment, another important government function. So the IPCC, I think, in some ways plays a governance role by providing regular assessments of climate change science. Coordinating function, so simply coordinating what different actors are doing, so they're acting in a way that reinforces each other or doesn't duplicate effort. Another important governance function. An information function, providing information on an issue by requirements about transparency, reporting of data, publication of research results, another important governance function. Facilitation, providing assistance, technical assistance, financial assistance, that's also part of governance. Regulation, decision-making, I've already mentioned before. That's, I think, what a lot of people think about as governance. But oversight, yet another governance function, providing monitoring so we know what countries are doing. And then finally, dispute settlement. So the question is, which of these governance functions would be a good idea? Which of these governance functions is actually realistic to think that international law could do with respect to climate interventions? So one governance approach that's gotten a lot of attention recently is a moratorium on deployment. So this would be a governance approach which would be to say no deployment for the time being at least. And so that's gotten quite, as solar geoengineering has gotten more attention, I think there have been growing calls for a moratorium on deployment. So Sue Binney and I wrote a paper called Why a Moratorium on Solar Radiation Management Deployment Should Get a Chilly Reception. So I wanted to just go through some of the reasons why I think a moratorium as a governance approach doesn't make sense. I think the issue really, if you start from the two premises I had at the beginning, which I think at least many of you seem to agree with, which is that research is needed, at least, well, I'm not sure you agree. Anyway, I will just say my premise is solar radiation management research is urgently needed to better understand the risks and benefits, but the deployment is premature. Then the question really about thinking about a moratorium is a moratorium the best way to promote research while deferring decisions on deployment? So that's the question, because those are the two goals: defer decisions on deployment, but promote research. And is moratorium going to be a good way of doing that? And we had 5 reasons why we thought moratorium was actually a bad idea. One is, and I'm going to go through these, but I'll just read them now. Reaching agreement would be very difficult, so I think it's very unlikely actually you would ever get agreement on a moratorium. Secondly, it's unlikely to be effective in preventing deployment. Third, it could end up actually chilling research rather than encouraging research. Fourth, it would be very difficult to unwind. Once you get the moratorium would have a tendency to become permanent, like a permanent ban. And fifth, that negotiating a moratorium would be very time-consuming and distracting. So let me just go through these 5 reasons why I think a moratorium is not the right governance approach for solar radiation management. So first of all, reaching agreement would be very difficult, if not impossible. The reason I think is that proponents of moratoriums, I think, have quite different views as to what they want a moratorium to do or why they want a moratorium. And that then leads them to support very different ways of designing the moratorium. So I think for some people, it's actually, they just believe in a moratorium because they think we need more time to promote good governance and deployment. So that's sort of the sincere supporters of moratorium. And then there are the 2 less sincere supporters of moratorium. On one side, there are the people who think, basically don't want geoengineering, period. They want a ban, but they don't think they can get a ban, so a moratorium is sort of a softer way of getting a ban. So they really want the moratorium functionally to serve as a ban. And then conversely, there are those, I think, who want to use a moratorium to create a safe space for research. So really the focus is on promoting research. And one of the barriers to research is people are worried about deployment. So if you take deployment off the table for the moment through a moratorium, that will then provide a safe space or a social license for the researchers to go ahead, because then that will deflect arguments that the research is going to lead to deployment. Deployment has now been taken off the table for the time being. So different views about why you want a moratorium, and then that's going to lead to quite different views about how you design the moratorium. Should it be broad or narrow? Which kinds of climate interventions should it apply to? What actors should be covered? To what extent are you covering just states, or are you covering private actors? At what level it should be adopted and by whom? Should it be binding or non-binding? And in particular, how would it end? Would there be a time limit to it, or would it go on indefinitely until some criteria was met? I think people who want the moratorium to serve as a ban are going to have very different views about what the moratorium should look like from those who want moratorium to simply create a safe space for research. People who want it to serve as a safe space for research, for example, might want the moratorium to be combined with calls for greater research, where, of course, those who don't want research are going to oppose that. So I think it's pretty unlikely you could get international, if you're trying to do this as an international kind of agreement, a negotiated moratorium, I think it's actually not just difficult, but probably impossible to get agreement on what the terms of a moratorium would look like. Even if you did that, even if you succeeded in getting the moratorium, I think the moratorium isn't going to be really effective in doing what the proponents of a moratorium want, which is to prevent research from deployment from taking place, at least for the moment. Because the countries that are the ones who are going to be most influenced by the moratorium are the countries you're not so worried about, who are behaving responsibly and actually are going to follow what the international rules are. The countries that you're most worried about are the ones who are going to be least likely to actually pay attention to the moratorium. First of all, they might not accept the moratorium in the first place. And international law only binds those states that consent. So if China or Russia or the US or the countries most likely to go ahead with, be interested in geoengineering, don't like the moratorium, they simply wouldn't sign on and wouldn't be bound by it. But even if they did sign on, if they really were motivated to use climate interventions, I don't think the fact they've signed on to a moratorium would be likely to prevent them from going ahead. So even if it could be agreed, I think it's not really going to be likely to be effective in actually preventing climate intervention deployment particularly by irresponsible actors, the ones who are going to be least likely to be bound by international norms. Third, I think moratorium could actually chill research rather than unlock research. So at least if you're like me, I think it's important that we actually try to increase the amount of research being done, then I think the moratorium is not probably going to be a very good tool. It's not clear that the reason why there's so much reluctance to do research is the absence of a moratorium, or that if you were conversely a funder, you would be more likely to fund geoengineering research if a moratorium were in place. There's no empirical evidence of that. I've seen no evidence that, as a factual matter, a moratorium would make research more likely. I think instead, actually, it's highly, this again, I have no empirical data, so this is again speculative, but I think it certainly can tell a story that a moratorium on climate intervention would actually delegitimize it. Because why would you have a moratorium on something unless it were bad? And so I don't think a lot of people will distinguish between deployment and research. They'll think moratorium on climate intervention, questionable, problematic, and then will actually make it less acceptable to do research. Interestingly, most things on climate interventions are heavily overinterpreted. For example, the Convention of Biological Diversity Parties adopted a decision back in 2010, which basically called for a moratorium on anything except research. So that was 15 years ago. That's had no effect. Usually that's cited as why we shouldn't do climate interventions, even though it actually explicitly allows small-scale scientific research. Usually cited as why we shouldn't do it, rather than creating a safe space to allow research to take place. I think there's no evidence that research has increased as a result of the 2010 Biological Diversity Convention decision. In fact, it's been quite the opposite. Opponents of solar radiation management cite it all the time, cite it in ways that it doesn't, about things it doesn't say, to basically cast into doubt solar radiation management research. Fourth reason is I think it would be difficult to unwind a moratorium. So once you had, unless the moratorium had actually a fixed duration, it would likely just become permanent, because unless it had a fixed duration, if it depended on some decision to lift the moratorium, then it might be impossible to get agreement that the conditions for lifting the moratorium would be met. For example, if the moratorium were a moratorium until effective governance is established, there's going to be massive disagreement among participants as to what effective governance means, whether that condition has been met. whether the moratorium needs to be kept in place or whether its conditions are right for lifting it. I think without a fixed duration, the moratorium will effectively become a permanent ban. The whaling moratorium, moratorium on commercial whaling that was adopted in 1982, so more than 40 years ago, which was only supposed to last for a short period of time to allow a scientific assessment of whale stocks, has basically become a permanent ban on commercial whaling, even though that's not what the original idea of it was. And I think the same would be likely true of a moratorium on deployment of geoengineering. If you did have a time limit, of course, that concern wouldn't exist. But I think a time limit, saying we're not going to deploy for 5 years or 10 years, wouldn't at all satisfy critics of solar geoengineering, because we're not going to probably deploy anyway for 5 or 10 years with or without a moratorium. So unless the time limit were way off in the future, I think many of the supporters of a moratorium wouldn't be satisfied with the time-limited moratorium. And then finally, negotiating a moratorium would, I think, be time-consuming and distracting. You'd be spending a huge amount of time trying to negotiate the moratorium, probably unsuccessfully. I think probably during that period of time, many would say we shouldn't be doing research until the moratorium negotiations are finished, but the negotiations might never finish, in which case then you'd just be further delaying research, which in my view at least is we need to be doing more of rather than less. Okay, so if a moratorium is not a good idea, so what are some of the alternatives going forward? Of course, many people, I think there should be development of some kind of international decision-making process to make decisions about whether to authorize geoengineering. So some centralized decision-making process. That, of course, would require a rule saying, in the absence of authorization, in the absence of a decision to authorize, geoengineering is prohibited. So there'd have to be a prohibition generally, and then with authorization being necessary to go ahead. So it would be structurally quite like the UN Charter on the Use of Force, where Article 2 of the UN Charter prohibits the use of force between states, and then Article 51 says, then the Security Council provisions authorizes the Security Council to authorize the use of force. So the prohibition coupled with a decision-making procedure for authorization. Now you can see how well that's worked with respect to the use of force and actually preventing the use of force without Security Council authorization. I think a similar structure for geoengineering would be have the same problems, that the prohibition would not be effective in actually keeping countries from using geoengineering if they felt sufficiently motivated to do so. So I think it's, first of all, extremely, could it be adopted? I think, again, it's unlikely you'd get any agreement to that. I doubt you'd get agreement now to the UN Charter, actually, if it was renegotiated now. The UN Charter was agreed to right in the wake of World War II. But I think then trying to negotiate something similar with respect to climate interventions, unlikely to be accepted, and then even if it were accepted, unlikely to be effective in actually preventing geoengineering. I think it's unrealistic to think that we can develop a multilateral decision-making process. And I'm not even sure, it's debatable whether multilateral decision-making guarantees a better result, because multilateral decision-making makes it very difficult to do things. So it all depends on whether you think the risk of engaging in something is worse than the risk of not engaging. The decision-making process multilaterally puts the thumb in the scale against going ahead, but if you're in the midst of a climate emergency, it's not so clear that's necessarily where the presumption should be placed. I think the same problems exist with respect to other proposals to create a liability and compensation regime. I think, again, just as somebody who's been engaged in, maybe I'm just too beaten down from 30 years of climate negotiations, and I don't have sufficient optimism as to what could be agreed, but sitting through more than 10 years of discussion about compensation for loss and damage for the damages from climate change, which have made pretty modest progress, I would say, quite unlikely states would agree to provide compensation for damages for
geoengineering activities that went awry. There'd be issues about causation. There'd be all sorts of issues about trying to show the damages. But even just getting agreement on the concept, I think, would be unlikely. So what do I see? So my more upbeat part of the lecture, what could be done, since I've been really a downer so far in terms of what international law could do here. So I guess I think I think you have to recognize international law is not the strongest area of law. It doesn't. So you have to be realistic about sort of what you're dealing with to what it can realistically achieve. So I think international law does do okay in terms of procedural norms, things like norms about providing assessments in advance, notification and consultation with other states, transparency. Those kind of norms don't always work perfectly, but there's much better compliance with those than because those norms are easier to satisfy. And I think they don't prevent something from taking place, but they at least allow a more robust discussion. They ensure that there's at least opportunities for others to be aware of it and to push back in all sorts of ways if they so choose. And then I think also, this wouldn't be agreed to, but I think trying to develop, informally at least, some evaluative principles to evaluate climate interventions. I draw these with some trepidation from the literature on humanitarian interventions, which has gotten has not done well in terms of how it's worked, but with respect to use of force for humanitarian purposes, use of force, for example, to prevent genocides, which sort of had a period in the 2000 to 2010 when there's a lot of focus on that, and various actors tried to develop rules for when it would be okay for a state to use force for humanitarian purposes to prevent, for example, a genocide or ethnic cleansing. And so some of the principles that were established was countries need to have the right intent. They need to be doing it for the right reasons. They're not doing it to try to conquer the other country or to colonize it. They're doing it to stop human rights atrocities from taking place. It has to be a last resort. They have to try every other thing first before they resort to using force to try to stop the genocide from taking place. And they need to have a reasonable prospect of success. It's not okay to use force to try to stop something where it's not going to work. It's not going to be effective. So you can think about these in similar terms, I think, with climate interventions that try to implicate norms about when climate interventions might be okay, that it would require the right intent, not for hostile purposes, for example, last resort, reasonable prospect of actually preventing serious climate change. These norms would not be these norms I don't think could be adopted in legal form. They'd be more like general norms that you're trying to promote internationally to try to create at least the ability to have standards to criticize, to evaluate, to justify climate intervention. So I think those kind of more modest roles are perhaps more likely or possible to achieve, and so I think that's where more of the focus should be. So just in terms of my summary here, what international governance functions are most likely to be achievable? I think forum for discussion, yes, I think that certainly is possible, and there are a number of different institutions where those discussions could take place. Coordination of research, I think, is beginning to take place, and that I think is likely and would be positive. Informational norms, I think, certainly are within the realm of possibility. Standard setting, as I say, I think the standard setting would be more procedural rules, soft law kinds of norms. Decision-making, authorization, unlikely, and dispute resolution, I think, also unlikely. So this is my, at least, assessment as to what international law could try to do to try to provide at least some governance of climate interventions going forward. So thanks a lot, and look forward to questions.
Thanks very much, Dan. We have time for some questions. Dan, I want to ask the first one. So your discussion of the idea of the moratorium, Pascal Lamy, who proposed the moratorium, I think he did it exactly for the reasons you said, which is he's not a climate person, he's a diplomat. And he was trying to get the group who wanted to ban it to agree to something along with the people who wanted to promote it.
Right.
And his argument to people who wanted to promote it, you didn't quite address, which is, he argued, and again, I can see all sorts of flaws with this argument, but he argued that the advantage of a moratorium is that you set the conditions. It doesn't have to be a time limit, it could be a global temperature limit or something like that, where it ends that explicitly then give you permission to do it. So that is, he argued that a moratorium is a backdoor towards actual deployment, which is kind of a funny argument, but he certainly made that argument very clearly, that if you're going to do a moratorium, you have to define the limits to it and the threshold across which it would no longer apply, which would essentially give implicit permission to then do it once that threshold is crossed. That's a little bit different than what you described, and I'm curious about how that fits into your discussion.
Yeah, so that, I did not hear him say that, and so that would be a way to unwind it, so it would be automatic essentially. It wouldn't be a time period, but it would be a criteria that was met. So I guess if I were
the easiest
designing...
would be to think of global temperature.
Global temperature, right. So yes, if you were going to go down that route, I guess that would be the most promising route.
I mean, I think what he was thinking
take.
was 2 degrees or something.
Yeah,
like that.
yeah. Of course, then we're probably going to be crossing it pretty soon. Would that satisfy, do you think, people who are concerned about climate intervention? So I guess the question is that going to be, so yes, from my perspective as someone...
He's the negotiator, he's the diplomat, right? And
right.
he's the one who thought that he could get everybody in the room.
He hasn't sat through 30 years of climate negotiations.
Yeah.
So I think, yes, well, maybe. Yeah, so I guess if you were going to go down that path, I think that would be a promising way to try to do it. I guess I'm still skeptical you're going to be able to achieve that. If you had a pretty low threshold like that, then, I mean, of course, the easier it is to lift the moratorium, the more likely it will be effective. So the stricter the moratorium, the more chance countries won't abide by it. So there's so that would not only address the point about difficulty of unwinding, it would also address the point about how effective it would be. But I guess I have some question as to whether a moratorium that was relatively easy to lift like that would be enough to address the critics.
Yeah, I mean, maybe 2 degrees is the wrong number, but I could imagine countries saying, okay, if it gets to 3, then maybe,
right.
then all bets are off.
But 3 might be, on the other hand, then you've now established a rule, basically until you got to 3 is off the table. And so maybe 3 is, by then it's
that's
kind of catastrophic. So.
Yeah. Floor's open for questions. Hold on, start.
That's terrific, Dan, thanks. So could you talk about politics? I mean, are nation states following climate blocks, AOSIS, et cetera, or do the national alignments really not track its more specific interests within each country? How do politics work out on this?
On this issue. So there isn't very much politics on this issue so far, interestingly, because it really hasn't engaged policymakers that much. So, and I think that's a real problem now because the policy discussions are pretty poorly informed. I was not at UNEA, that's the UN Environment Assembly, where the Swiss proposed a couple of times now resolutions on climate interventions. And my understanding from people who were there was just a lot of ignorance about climate interventions and what the Swiss proposal would do. The African climate ministers adopted something in, I believe it was in July or August, essentially calling for a prohibition on climate interventions. But again, what that was based on. What happens now is there's some very strong advocacy groups, largely against climate interventions, who are very active in lobbying governments. And because there's not a lot of lobbying on the other side or groups that are present and active, they have a big influence. And so at the moment, to the extent there's been international decisions, I think it's really the African group, they've been negative.
whether they would have those views, where those views were considered and how high up, I think is a question. Small island states haven't really been involved thus far. AOSIS, for example, that's the Alliance of Small Island States. So I think I'm doing a negotiation simulation in my international environmental law class in a couple of weeks, where they're supposed to negotiate a treaty on climate interventions, and I've assigned them all different countries, and I've been trying to figure out. They're supposed to just sort of look at their country, figure out based on what they understand the interests, because there are no positions out there. In most cases, they can't go on the web and figure out what the Maldives position so far on climate interventions is, because I don't think there really is much.
We had an undergraduate last year write his senior thesis on geopolitics of solar geoengineering, arguing that basically it was two dimensions. One was how much you were going to be impacted by climate change,
Sure.
and the other was how much your economy is affected by fossil fuel production. Because both enter into the, you can imagine.
But I think a lot of the attitudes are also that climate interventions will be done by northern rich countries and will be done in a way that only benefits northern rich countries, and they're not going to care about the impacts on the global south. And so I think there's a lot of those kind of fears that enter in. So even if you're an extremely vulnerable country that might, potentially have some benefit from climate interventions to limit climate change, you don't think it's going to be done in a way that's going to actually help you. It's going to be done in a way that, completely disregards or ignores the effects it's going to have. So I think there's a lot of that concern, which has certainly some justification, I think.
Back here and then into the thing.
Thank you so much. Building on that point, I have a question about the difference between the threat of solar geoengineering and the actual deployment. And going back to your point about a coalition of the willing, obviously there's a huge gap in global adaptation and loss and damage financing. Do you think it would be a credible threat for a coalition of countries particularly vulnerable to, say, extreme heat to threaten solar geoengineering in the future if they don't receive greater funding?
Well, that's an interesting concept. The question is whether they could credibly threaten. It's not necessarily technically that easy to get enough planes into this, high enough altitude to be deploying enough stuff to actually make a big impact. But yes, I think that's I haven't actually thought about that, but that's an interesting idea. Yes.
Thanks for the stimulating talk.
By the way, I think, though, there are all sorts of other ways. If you're a weak country that, if you don't have the support of, China, the U.S., you might not want to. Apart from your threat might not be credible because there'd be pushback. This is not exactly on point, but sort of on point. U.S. just managed to block adoption of rules in the International Maritime Organization to deal with emissions from ships, from vessels. So the International Maritime Organization was poised to adopt a decision to try to limit emissions of greenhouse gases, carbon dioxide from international shipping. Trump administration strongly opposed that, but not only did it not attend the meeting and not support it, it actually actively pushed other countries to reject it. They threatened trade sanctions, they threatened visa denials. They used all sorts of instruments of power to basically threaten other countries not to vote in favor of this IMO decision. And they were successful. The IMO decision was delayed for a year. So I think if a small group of African countries said, we're going to unleash solar geoengineering, if you don't give us a lot of money, my guess is the reaction would be, not we'll give you the money. The reaction would be, well, reduce you to rubble if you go ahead with that. Well, that's maybe just extrapolating, but exaggerating.
You focused on deployment by governments. I've seen estimates that say if Amazon lent their industrial might to pull off solo geoengineering, it's plausible that they could. And I wondered if you could speak to what the law has to say about legal hindrances to corporations or specific wealthy philanthropists to undertaking this.
So I think there's a huge amount of focus on developing international governance. There's a lot of big literature, at least. There's not much politics on it, but there's a big social scientific literature on developing international governance. But I actually think at the moment the bigger gap is in national governance, national legislation, because I think I've never seen a survey done, but my guess is that most countries don't have effective regulation of activities by private actors on geoengineering. So there was the case in Canada where Russ George dumped a bunch of iron into the ocean off British Columbia to try to fertilize the ocean and take out carbon dioxide. And there was, a question as to whether Canadian law actually addressed that. There was the making sunsets, one in Mexico, where again Mexico said it's illegal, but exactly what law they're breaking. And I've seen some analyses of U.S. law, and not really clear exactly what things would be prohibited under U.S. environmental law in terms of geoengineering activity. So I think before you get to international governance, which is super hard, something easier, hopefully, would be to get some national regulation so countries would assert jurisdiction over, assert jurisdiction over actors or activities in their territory in geoengineering so that Amazon can't just go ahead and do it. There'd be some rules about, for example, notification. I'm not sure what the law could say. It could say different things. It could prohibit it, but it could also have norms about assessment, notification, transparency, and publication of research results, and so forth. That's at least if they were doing research in this. So I think a starting point would be, a lot more focus should be put on getting countries to adopt national laws that effectively regulate activities by private actors on geoengineering.
Okay, a couple more. One over here and one over here.
Even in countries which agree now on certain policies, 5 years from now or 10 years from now, there may be a new political party which may reject the previously agreed upon policy. So now, is there any way that in that situation, in the future situation, there can be something like a binding decision overall?
I think the history of the U.S. over the last 12 years shows that policies only last for 4 years, and then the policies are, completely changed. So I think that's a big problem because to do climate interventions, if you were going to do it, you need to maintain it over a long period of time, and in the current political landscape, sustaining policies over a long period of time are very difficult. So that's why on deployment I'm very, agnostic. You'd have to try to figure out some answer to that question. Maybe there is no answer to that question. I'm not sure. I don't think that applies to research. So I guess I would at least be in favor of, researching it so we better understand. So, but whether there's ways of trying to do geoengineering that would be robust against political changes. But yes, I think that's a big issue. Agreed.
Hi. So for your two potential ways where international law could be effective, for the second one you gave kind of an analogous example that has happened. You said humanitarian vote by a Security Council. But for the first one, procedural norms, do you either have like a kind of analogous example of where there was a set of norms and countries actually did follow those, or have you heard existing discussions of maybe more specific examples of what could be a procedure in this case, or a procedural norm?
Well, this is a very perfect analogy, but it's at least a little bit. So on use of force, for example, there's the substantive norms, which is to prohibit use of force except in self-defense or unless authorized by the Security Council. Not very good compliance with that, I would say. There's in addition to that actually a requirement, a procedural requirement that when you do use force, you're supposed to notify the Security Council and provide reasons for your justification for why you're using force. So actually,
that's pretty well complied with. So when the U.S. bombed Iran, for example, whether or not that was justified under Article 2.4 of the UN Charter, I'm going to be discussing that in my class next semester when I teach use of force. But I think it's highly questionable whether it met the substantive requirement. The U.S. did file an Article 51 letter to the Security Council providing that it was using force, that it was doing this, that here's why. So it's pretty easy to do that. It's pretty costless. Does it serve a function? Well, at least it provides the reasons why, explanation, the stated reasons for why the U.S. was doing it. It provides then a basis for others to criticize, saying, no, that's not doesn't meet the requirements of the UN Charter, et cetera. So that's an example of a procedural norm, even in the area of use of force, where law is particularly tenuous in its effect, where it does have an effect. But I think in a lot of treaties, there are reporting obligations, and the reporting obligations aren't perfectly complied with, but the reporting obligations, are reasonably well complied with, even when the reports, show that the country is not doing so well in meeting the obligations.
So people are starting to slip out. Let's get 2 more questions, and then we're going to stop. But I think Dan might be available a few minutes afterwards.
And there was one down here in the front.
Thanks, Dan. So lots of your hesitancy about the moratorium has to do with being unlikely that there'll be some disagreement, and then all of the negotiations being quite costly and distracting. I guess I'm wondering whether you think there's any value to the negotiations themselves independent of the prospect for agreement. So it seems to me like the type of questions that discussions over a moratorium press us to ask and try to answer together are the right sort of questions. So to Dan's point, questions about the circumstances under which geoengineering would be justified, the circumstances under which we should pursue more research in this dimension or that dimension. So yeah, just curious whether you think that independent of the potential outcome there might be value to the attempt.
So the question is whether the 10 years spent negotiating a moratorium unsuccessfully would lead to, that's just a guess, would actually be useful use of those 10 years, because they'd be, some X years of negotiations would be useful or not useful. So I'm not sure that's the most useful way to have the discussion. So I've been sitting and attending, because I'm now studying the plastics negotiation. So we've had now 3 years of negotiations on the plastic treaty with no result. Negotiations broke down in Geneva in August. So have those 3 years been useful in promoting better understanding of the problem of plastic pollution? Need to think about that. Okay, so I'm not going to give you an answer, sorry, but that's a good question. Yes, it's a question I should think about more.
Final question.
Thank you so much. I have a question about what I sort of perceived as basically a hidden premise that you referenced a few times but didn't put on your slides, which is that you can separate out research on solar geoengineering from the likelihood that solar geoengineering happens. So my fear would be, if lots of people do research on this, you're both going to create constituencies, let's say certain countries or certain regions, that view it as in their interests, and they see that in the research and they think, actually, this is a good idea. And you might also create constituencies who just on like a really practical level think they're going to be the ones doing this and they have something to benefit from. Thinking about like the history of nuclear weapons in the United States is basically each military branch thinking it's going to be in charge, and so then really pushing the development of nuclear weapons because it makes them comparatively more powerful. So my question would be, if there were a moratorium on research of solar geoengineering and on doing it, do you think you and other researchers like you, I know there's at least a couple people in the room that are researching solar geoengineering, would be less likely to research it? This isn't whether China will be less likely to do it, but like, do you think that would chill research? If you believe that research inevitably increases the probability of it happening and you believe it's bad,
yes,
then the moratorium does actually have value, kind of contrary to all.
Yes, so that one of the arguments against doing the research is the slippery slope, that once you start doing research, then it'll make deployment more likely. So I guess if you think that's the case, then yes, you don't want to do research. And so my initial premise, which is that I think we should be promoting more research and we need more research, you wouldn't agree with. So that's not my premise. My premise is, yes, there is a slippery slope issue. So it's not. But if you think about what are the risks of doing research, like mitigation, deterrence, or slippery slope, so those are, I think, the two main ones that are cited. The risks of doing research, and then the risks of not doing research, which is we don't understand geoengineering. Countries might in desperation do it in a way that's completely ineffective or super unsafe, and there might be better ways of doing it. I guess I think the risks, or that climate change will go to 4 degrees and there'll be nothing to do to try to counteract it. I guess I think the risks of not doing research are much greater than the risks of doing research. So that's why my starting premise was we should be promoting research. But yes, if you don't want to go, think it's a bad idea, research is a bad idea because it leads to a slippery slope and will lead to use of it even if it's unsafe, then you don't want to be promoting research, and then a moratorium research would be a good idea. Well, you wouldn't want just a moratorium on deployment. You want moratorium generally. So yes, but that's not my starting point. At
There's
least.
another argument that we've been making for 20 years. The community. I talked about this 20 years ago with Keith in a big workshop here, which is that public research by scientists who publish openly is far preferred.
Yes.
Because the research is going to happen within the military-industrial complex. It's already happened. There were people that once lived were doing this work under the tutelage of Edward Teller in the 80s. So the idea that you can stop research is naive. What you can do is bring it into the public realm, and that creates a certain amount of openness, and that actually is much more important than supposedly banning research, which just means it goes underground.
Yeah. I mean, I totally agree. You want to be encouraging research done in the right way, and I would include notification, a registry of what's going on, publication, commitment to publish the research results rather than keep them proprietary, things like that.
And actually, it has some analogies to Eisenhower's decision to move the whole decision in the U.S. over many years to move the nuclear energy regulation into the civilian realm and out of the military realm.
Right.
So, this has been an interesting hour, and we're going to have a number of these events over the course of this year and in future years. I just want to quickly introduce you to John Prendado, who just arrived at Harvard. John, want to stand up just quickly? John is a new, he's managing the Solar Geoengineering Research Program, so he'll be organizing a variety of talks, not just on governance, science of solar geoengineering, all sorts of things. So you'll see John a lot. Dan, thanks very much for coming. We hope you're back. Thanks.
Thank you. Thank you all.